So I think we may start. I already shortly introduced Andrea Bertolini, who is, I think, one of the people working more on the legal implication of robotics and AI. He actually has been heavily involved in the RoboLaw project, which was a project actually led by the law faculties of our university, which actually the main output was a set of guidelines for legislation on robots provided to the European Commission. But you will know more from Andrea. Andrea, so the floor is yours.
Thank you very much for the invitation and for the opportunity. It's always nice to talk, for a lawyer to talk with engineers about the regulation of robotics. In the first place, to defeat a common assumption that is always wrong, and namely that law is a hindrance for innovation. Law can be a powerful tool to foster innovation, and law can be an essential tool to enable the emergence of prototypes that you as engineers research and develop in your laboratories into market products. The only problem is to have the right laws. The only problem is to think practically in a very concrete fashion about the law. So what I want to tell you today is, first of all, what RoboLaw is and what it is not. What are the fundamental conclusions that RoboLaw reached? I will then in particular address the issue of risk management that is of particular relevance in order to create an adequate framework for robotics and for the emergence of robotic products. And I will try to show you a broader picture of what is happening outside Europe at the same time, while the RoboLaw projects and our researches here with the European Commission and European Parliament are ongoing. And I will also show you the present and future of RoboLaw, so what is happening now in our research line and what will happen in the next few years. So what RoboLaw is and what it is not. This is a very important thing to clarify, because very often when you talk with someone about RoboLaw, they understand this to be somewhat related to Isaac Asimov laws of robotics. But RoboLaw actually has nothing to do with that. RoboLaw originally was a FP7 project of the European Commission, financed by the European Commission, and as Fabio just mentioned, we came up with a series of guidelines that basically analyzed the most relevant and emerging robotics, some of the most relevant and emerging robotic technologies and the legal and ethical issues they pose. Overall, we never intended, and we do not intend today, to compete with Isaac Asimov and develop what may be considered the code of robotics or the law of robots. Robots as of today are things, so there are no laws for robots. There are laws for robotics as an emerging industry, as an emerging area of social relevance, but that is something completely different. So we're not interested in anything related to science fiction and what may be seen as rewriting the laws of Isaac Asimov. Those were a very interesting thought experiment, a very nice piece of literature, but this is something very different from what we do. What we do is a very empirical and a technical analysis of the existing legal issues posed by emerging robotic technologies. And so what RoboLaw is, I already mentioned it to some extent. Mostly it's a methodology that we elaborated to address the ethical and legal issues of some kinds of robotic applications. And as Fabio just mentioned, we came up in 2014, when the project ended, with what is called the guidelines on regulating robotics. So some people may refer to this as a white paper. Technically, it's not a white paper because a white paper is issued by the European Commission, but it is an advanced, over 200-page long technical analysis of the legal issues of some robotic technologies. And its aim was to provide the European Commission and the European Parliament, where these guidelines were presented, with a technical analysis of the issues that the European legislator should address in order to enable the emergence of some robotic technologies onto the market and the development of a European industry for robotics. Several studies in by different sources, in particular investment banks, are showing that robotics is an extremely promising industry. The problem with jobs could also be seen in that perspective. Many people claim that robotics will take away jobs. Actually, it's reasonable to assume, and that is quite certain, that robotics will have a gigantic and positive impact on the economy, on the market. So the only question is whether we, as Europeans, or Chinese in China, Americans in the US, also want to become, and to what extent, players in this market, therefore produce innovation in robotics and produce robots as products. So the European Union was extremely interested by this kind of reasoning and this kind of approach, and I can tell you that a commission in the Parliament, in the European Parliament, has been established that is working currently on those guidelines to see what they can do about them and what about them could be implemented into some new European regulation. So what are the fundamental ideas that RoboLaw built upon, that were at the basis of our analysis? Robot is an atechnical term. That is true also from an engineering point of view. If you wanted to define what a robot is and you spoke with different engineers, everyone would come up with a different solution. And this is due to the fact that there are so many different kinds of robotic applications that are being researched that are so diverse from one another. So apparently you cannot identify a common trait to all robotic application, because if you take a robotic prosthesis into account, it's extremely different from a soft boat, and like Dr. Watson, and so on and so forth. So the robot it was born as an atechnical term. It was not derived from engineering, it was derived from science fiction, and therefore there is no way to define robots unitarily. If we cannot define robots unitarily, you cannot also develop solutions that are common to all robotic applications. You cannot craft the laws of robotics also because robots are so different from one another. So this is also the reason why it makes no sense for us to discuss in terms of Asimov's laws of robotics, because we have to find practical solutions to practical problems that are different according to the technical peculiarities of the applications that we're studying. And that's the reason why we adopted, for the first time in this field, a bottom-up and functional approach. Bottom-up meaning that we did not try, like lawyers normally tend to do, to craft a pyramid where the system is extremely general and on top, and then comes down and regulates all the different subsets of applications that might emerge. But we start by working with engineers to study some kinds of robotic applications through a methodology that allows to identify the legal issues that a single application gives rise to, and address those technically and find a technical solution to that. In a way that is not that very different from what an engineer would do to solve a technical problem to his, for his prototype to address a specific task. So there is not an all encompassing definitions of robots, and I use this slide to explain to people that are not into robotics, so I don't need to indulge too much in that with this kind of audience. But there are so many different kinds of robotic applications. Like I said, a robotic arm, Dr. Watson, a surgical robot, a driverless vehicle, and the dashboard that we have that was developed here in Pisa, that all fall under the name of robot and of robotic application, and they're also different from all dictionary definitions that you may find. If you take the Oxford English Dictionary, you'll find a definition of robot that is basically recalling Terminator, but has nothing to do with any of those applications that I'm showing up in the pictures here. And this is precisely the reason why we cannot address them unitarily. What does a functional approach to regulation mean? So there are profound technical differences among different robotic applications, and this forces a case-by-case approach. This case-by-case approach is not intended to be so specific as to distinguish, for instance, a robotic hand from a robotic leg, or a specific prototype of robotic hand from a different one. But yet it is more like for classes of applications. So from a legal point of view, the kind of problems that a robotic hand and robotic leg may pose are quite similar, and so they can be treated in aggregated fashion. What you cannot do is to put them in the same box with the driverless car. So we had to adopt a classes of application, let's say, approach. We address the different classes of application as a case-by-case approach. Then we also noticed that similar technological traits, for instance, the ability to operate unattended or autonomously, may identify that are maybe common to the single to different classes of application, may not give rise to the same kind of legal issues. So the ability of a robot companion to operate unattended does not give rise to exactly the same legal issues as a driverless car. They both operate autonomously, but they identify and give rise to different legal and ethical problems that need to be addressed with different strategies. So overall, this forces us to identify the specific impact of single applications on society in a legal and ethical perspective. So even the common technological trait requires an attentive analysis in all single cases to identify the specificities of the problems that they give rise to. And finally, even the same legal issue, one legal issue that is common to all robotic applications is that of liability. So who pays for damages when something goes wrong and some harm occurs during the use of a robot? Even the same legal issue may require different solutions. So solving the liability issue with respect to driverless vehicles is a completely different question than solving the same legal issue with respect to a robotic prosthesis, just to give an example that I used before, or a soft boat. It requires a different approach, a different technical approach, technical meaning in a legal perspective, of course. And so what we need to focus upon is to conceive the right sets of incentives. So we have to think of law as a tool to engineer society. And we have to think of rules as a tool to provide the correct incentives to the different players, being researchers, producers, or even users of robotic technologies, to act in a risk-minimizing way and utility-maximizing way at the same time. So these were the fundamental assumptions, and therefore we adopted this methodology that we are still using today, and we think that is the best approach to studying the legal and ethical implications of robotics. So we adopted a 4 case studies approach. Why 4? Because that were the resources, human resources and time resources we had. Of course, now we are studying different kinds of applications, and I'll show you in some of the last few slides are dedicated precisely to that. We chose those 4 case studies based on this 3-pronged test on their novelty, impact, and imminence. So the novelty of the application, the impact they may have on society, and how imminent they might be. So how reasonable it is to expect them to be on the market in the medium run, let's say. And we addressed driverless cars, we addressed surgical robots, robotic prostheses and exoskeletons, and robot companions. And of course, we could have addressed drones, and we are actually recently studying them. And you could address soft boats. And as I said, the only reason why we limited ourselves to those 4 case studies is because we thought that they were certainly relevant, but of course, maybe not even the most relevant. And definitely, there are other technologies that deserve the same kind of attention. The structure of our paper, that, by the way, you can download it for free from our website, that is www.robolaw.eu. It's structured as such. There's an introductory chapter and, of course, conclusions at the end. But each chapter analyzes a single class of application, one of the 4 case studies, and it's divided in 3 parts. So there's first a technological analysis. So we started by asking engineers to explain to us how these kind of applications work in a technological perspective, in a technical perspective, because in order to spot the legal issue, you have to clearly understand how the thing works. So we started with a technological analysis that was underwent by engineers here at the school and in other research institutions across Europe. Then we underwent an ethical analysis that concluded with some policy considerations. So basically, our philosophers were trying to identify what kind of ethical issues those technologies give rise to once they're brought in our society in light of our existing values. And they concluded their analysis with some considerations for the policymakers. And then we had a technical legal analysis where the same kind of exercise was done. Therefore, we took the single application and put it in the legal framework, and so what would happen if we applied existing rules, and what kind of incentives we would have, and what kind of impact that would have, and how we could conceive and what kind of incentives we could adapt in order to obtain a more favorable result, namely the correct cooperation of all actors, researchers, users, and producers. What are the most relevant conclusions? So, with respect to liability, that is one of the most relevant issues, we came to the conclusion that we need to stop thinking of liability in terms of fault, basically blaming people for doing something wrong, and adopt a more risk management approach, risk management centered approach. I'll explain that in a moment. We also said that in order to ensure safety of technological products, we need to address technical standardization. European Union and the West in general has always made use of technical standards for certification purposes and such, but those available today are largely insufficient. So we suggest the European Union to strongly invest in that direction, and that they're taking this into consideration. We also suggested the development of a European robotic agency precisely to tackle the issue of standardization. And we also addressed the issue of the necessity to enable real-life testing of robots, meaning testing of robots on public roads and in our cities to some extent. Of course, under conditions of safety. What is risk management? Risk management is a fundamental condition for innovation, because unless you identify a risk management strategy, you cannot turn a prototype into a product to be sold on the market. What is the problem with risk management? The problem with risk management is twofold. First of all, you have to identify the risks, and then you have to assess them, meaning you have to assess what happens if something goes wrong, if the risk materializes, what are the consequences of that risk materializing, and how likely it is that this will actually happen. I can hear some very strong noise. I don't know where that comes from. Okay. So the problem with the risk management process is that you do not know exactly what risks will materialize when it comes to robotic applications, because to a large extent they're very novel and they are groundbreaking. So in identifying risk, you have to distinguish material risks from legal risks. Material risks entail or depend upon the scenarios in which the product will be used and the different ways in which it will be used, and the consequences of the potential malfunctionings that occur in different scenarios and in the different ways the product will be used. So to give you a concrete example to think about, again, I'll use the robotic hand example. If you take a robotic hand into account, you can use the same robotic hand to perform very different tasks, like scratch your head or carry a bag or train in a gym or drive a car. Maybe to a large extent, the hold that you have to use to hold the steering wheel or the shopping bag is the same, or maybe even a tool in the gym. But the malfunctioning occurring in the different scenarios will lead to very different consequences. So if there is a malfunctioning of the robotic hand while you carry your shopping bag, you will break the eggs in the basket. If there is a malfunctioning while you are driving, you may cause an accident and involve someone else in that accident. So it's kind of difficult to foresee from an ex ante perspective exactly what will happen. And this is the major risk in not being able to precisely identify the risk that robotic applications will bring about. And also, the legal risks depend on the fact that existing liability rules were not thought with robots in mind and with their specificities. So, as lawyers, we have to some extent second guess which laws might be applied to robots and in which way they will be applied by the single judge. And we have to somewhat second guess what will be the legal consequences of applying those rules and once one of those risks verifies. So there is a high level of uncertainty. And how can we address that? Well, with respect to material risk, the best thing would be to undergo real-life testing. That is quite difficult in the Western world as of today. There are some differences in Japan. A good example of what could be done is what is being done recently with the Eckhart++ project, but this is still to a too limited scale. So it's very important to undergo real-life testing, because what is so peculiar about robots is their interaction in the real-life environment and in the real world, and therefore we need to be able to assess what are the consequences of their operation and of their interaction with human beings in the real world. And we need to invest in that direction. That is what we precisely suggest the European Union should be doing right now. With respect to legal risks, the problem, as I said, rests with the fact that there are not legally binding definitions. In some cases, for instance, in many European countries, there is no legal definition of driverless vehicle. This prevents driverless vehicle from circulating even for purely experimental purposes on streets. And also it depends on the fact that existing legal schemes may overlap. And I can explain that, like, product liability and traditional liability system overlap in these cases. So these legal risks require lawyers to start thinking the way we are doing. And this is the kind of exercise that lawyers need to do and come up with solutions, identifying the hindrances and what is wrong in the existing incentives and what should be modified in order to provide better incentives to people that are researching robotic prototypes and robotic products. When it comes to risk assessment, that is another very complicated part of the story, because we do not have statistical data about how often something will go wrong when we use a robot and what will be the consequences of that. So the lack of statistically relevant data prevents the possibility to insure for damages, because the way an insurance company works is to calculate a premium that is a function of the probability times the damage. So the probability of the damage occurring times the consequences, so the economic consequences of it occurring, which is the damage that they'll have to repay. So this causes existing or foreseeable technologies in many cases to be very hard to insure, and this certainly produces a technology chilling effect. What could be solving strategies to this? We have to undergo a technological risk assessment studies for specific technologies. That is what precisely we attempted to do with the RoboLaw project. Determine what applicable rules are and weigh the possible outcomes with the aim of promoting certainty to the extent that it is possible. And we work in tight contact with insurance companies to elaborate new insurance products, that is basically insurance contracts, to provide risk management strategies to producers of robotic technologies. What is happening outside Europe in the RoboLaw field, so in the regulation of robotics field? Korea has adopted the Intelligent Robots Development and Distribution Promotion Act. It's a very long title. That is a law that is basically creating favorable conditions for robot testing in real-life environments in the cities. Japan has created some deregulation areas, and that is also something similar to what is happening in Korea, and it's highly interesting for us, and that's what we are suggesting the European Union should also be doing. So creating areas where the testing in real-life scenarios of robots is enabled, precisely to address that identification and risk assessment issues that I have just been talking about. The United States is adopting a more limited approach. They are developing the conditions for some kinds of robotic applications, very specific, for instance, by adopting a definition of driverless vehicle that enables the testing of cars in some states and upon certain conditions. But this is a more limited approach than what is happening in Asia, and therefore we believe that what is happening in Asia, at least with the respect of real-life testing, is the way also Europe should be going. What is the present of RoboLaw? So as I said, the RoboLaw project is concluded, but this kind of research, this line of research is extremely active, and we're actually keeping on consulting the European Parliament and the European Commission on this. We are currently working on civil drones, and we're doing a regulation assessment of civil drones through an Italian research project that was recently funded. We're studying the existing Italian regulation of drones that was recently adopted by our National Aviation Authority, posing some rules to the use of drones, especially in particular with respect to liability, licensing, and so on and so forth. And we're undergoing a study that says what works and what does not work in that regulation. We will have a one-year time frame within which we'll come up with some policy considerations for the European, for the Italian authorities to tell them what they should keep and what they should change about their existing regulation. We are also starting in cooperation with the IMT, that is another Italian university in Lucca, alternative risk management strategies for driverless vehicles, in particular in cooperation with Italian and European insurance companies that do not know how to insure these kind of devices once they will be technologically available. And I am also coordinating a project that recently started that is more specifically on the liability models applicable to robotic prostheses and exoskeletons, that was financed by the Italian Ministry of Education. This project will be a 3-year project, and I will undergo an empirical analysis of product liability in Europe, United States, and also major Asian countries, including China, to see what works and what does not work in existing product liability rules. There are rules that hold the producers of each device liable, so even the producer of a robotic device is liable. And I'll come up with a conclusion about how they should be changed. Finally, we are also working on a summer school and a series of courses on the regulation of robotics that has been financed directly by the European Commission, and that will be held here at the Scuola Sant'Anna starting summer 2016 and for 3 years. The aim of this summer school is to train European lawyers and engineers of tomorrow, providing both with the necessary technical skills to cooperate together, because engineers need to start working in close contact with lawyers even during the design phase of their prototypes, in order to minimize the risks that the legal risks that their devices bring about. And here I have put a series of publications that are already out. This is the RoboLaw series that you can find on all major channels, distribution channels, including Amazon and so on, addressing various aspects of RoboLaw, so liability, human enhancement, and the approach to the regulation of technology. That is it.
I think we have time for one or two questions, maybe one question, and then we can leave to a round table. So, any question? So, personally, I have a comment, which is that it's nice to hear from a lawyer that we don't have a definition of robot. Mm-hmm. So, we are, which is nice. So, it's to a certain extent true. So
yes. So one of the deliverables of our project was to to look into the available definitions of robots, and we came up with, I think, a 30-page long report that was providing all the possible different definitions of robot that different engineers were providing, and all the possible different classification with respect to the control mechanisms and the presence of actuators, of embodiment or not of the robot, whether a soft body is a robot, and so on and so forth. And we came to the conclusion, I don't know whether those definitions do really make a difference in a technological perspective, and I'm not really interested in that kind of question. But from a legal point of view, we saw that this is totally irrelevant. So typically lawyers like definitions. Typically lawyers try to come up with definitions. If you open up the civil code of any country in the world, you will find a definition of contract, a definition of marriage, a definition of whatever is relevant in our society. But to some extent, providing an all-encompassing definition makes really no difference with respect to robotics, because the peculiarities are much more relevant than those elements that distinguish one application or one class of applications from the other are much more relevant than those things that they have in common. And in a legal perspective, if you want to undergo a technical legal analysis, you want to get into the details in order to come up with a solution that works. I think it's not very different from what you do in your daily research when you try to address a control problem. You try to address that specific control problem. You don't try to provide an overall solution to all the problems of that machine at once. You analyze them one by one, and you take them one by one into consideration. That's more or less.
I also have a very short question from Berlin.
Yeah.
So in your project there were lawyers as you, and also ethicists and philosophers. And I was wondering whether you agreed on many points, or what was the biggest disagreement between the lawyers and the ethicists?
Well, I think that there are very different approaches. One disagreement was more methodological but then it was solved. Ethicists tend to be more descriptive. Lawyers, and us in particular, tended to be more analytical. So our aim was more to come up with a bullet point, a conclusion to present to the European Parliament, telling them you should change law X into law Y, because otherwise nothing is done. Ethicists had more of a problem with this kind of approach. They are not trained to provide the ethical solution to the issue. But beyond that, so this is a more applied ethics approach, and it's not so common among ethicists. But they said then we managed to elaborate the solutions to that, and they came up with their more general policy considerations that are also quite useful. But in terms of content, the major overlapping only occurs when you take human enhancement into account. And there I think that the interaction of lawyers and ethicists is extremely positive, because ethical analysis provides a framework, a methodology that you then need to fill in with legal rules. Because even addressing such a touchy issue like human enhancement, we have constitutional rules. We have constitutions and constitutional laws in Europe that provide some guidance that we need to take into account when addressing the specific technical legal questions. So what kind of enhancement practice should be allowed and which one should not.
Okay.
Okay, thank you.
Thank you. So.